In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of highest votes in the election to be as contended here by petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded." The court went further to hold on page 2854 of the record that, quote, "Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election," end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I judge resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134 sub 2 of the 1999 Constitution makes it explicit that, quote, "A candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja," end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, "Election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption," end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, It is clear that the appellants, having not put forward their perceived rightful score to rebut the result put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties, and probably their counsel, should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed.
As court pleases.
The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed.
As court pleases.
I shall make no order as to costs.
As court pleases.